Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
I've got an individual in my section of the alphabet. We've not been appointed to him yet, but the court can call it.
All right.
He is probably not on the docket. His name is Marcus Ingram.
Okay.
He was supposed to be in court last time. He's got a violation of probation. Looks like he hadn't gotten his service work done yet or bought it out. He's present in court. Mr. Ingram, come on up. Ma'am, I sure do not. I tell you, actually, I do, because I brought it up on my computer. Go ahead and stand there. I will give it to you. Switch over. It looks like it's going to be 22 CF 2764.
And you're asking to be appointed to represent Mr. Ingram?
Judge, if you want to appoint me, I'll certainly be happy.
Is he here for arraignment, though, today?
Judge, he didn't get his CSW done. It looks like he was, and I'm not sure if he was in for arraignment. He and I apparently talked about it when he was in here before, and my understanding is that it was passed, and then he didn't show up last court date.
Is there a warrant for his arrest?
Yes, sir. So what I'd ask is that the warrant be rescinded. I've talked with him again this morning. He intends to buy out the community service work.
I'll withdraw the capias. Make sure you show up for court. You could end up in jail, and you won't have a nice, soft-hearted judge like me and make you sit there for 6 or 7 months.
Yes, sir.
All right.
Judge, when do you want him back for? I think we're just tracking him to get the.
Just
the
whenever,
service work paid.
let me see my calendar.
4/25 maybe is the next date,
How about that, April 25th?
if that's a VOP date. Madam Clerk, can you help me out here? It is, okay.
All right, April 25th, okay?
All right, Marcus. And Judge, am I appointed on him again?
Yeah.
All right, Judge. All right, Marcus, I will see you then. Just concentrate on getting that paid, okay?
Has anyone from the state heard from Miss Merrifield? Is Jessica Duffield here? Come on up here. You're here on a VOP. Is there an offer for Miss Duffield?
Yes, Your Honor, but it depends on whether or not she has she's done the evaluation for substance abuse.
I have an appointment for the evaluation. I turned it into my probation officer yesterday.
Is this Jessica Duffield?
Yes.
Yes, Your Honor, Ms. Globally for probation. She does have an evaluation scheduled for April 26th. If y'all want to just continue it to make sure she goes to evaluation and see what day.
That would be April 26th.
Yes, ma'am.
Why
So
don't
we
we-
should continue to sometime in May, please, Judge.
May 9th.
That would work, thank you.
All right, get that done, okay?
Yes, sir, I'm trying.
Or-
Thank you.
Thank you. Tanya Sullivan?
Your Honor, she's pro se, and she's in need of an attorney.
All right, you're here on a violation of probation. Is there any kind of offer or the? All right, I'll appoint public defender to represent you.
And Your Honor, we're going to enter a denial, and if we could set this off for a month, give me an opportunity. My understanding is she was on probation in the state of Alabama, so
What about May 9th? Is that a good day for you?
that would be fine. I'll get you my card.
Get with Miss Rivers so you get this straightened out, okay?
Yes, sir.
All right. Okay. Off the record or on the record?
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell.
All right, Your Honor, the first one that I have on out of custody would be page 5, number 15, Devin Robbins.
Devin Robbins. Okay.
He's before the court on 21 CF 2891. We've reached an agreement in this matter, and actually, I don't think
I got one.
oh, there is a score sheet. You did attach it then.
Are you Mr. Devin Robbins?
Yes, sir.
All right, this is State of Florida versus Devin Robbins, 21 CF 2891. You want to enter a no contest plea to leaving the scene of a crash with injuries, a third-degree felony?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
Yes, sir.
Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
State's going to null pros count 1.
That's correct, Your Honor.
Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudication withheld since the 3 years probation. No contact with Keith Lewis. Do not come within 500 feet of Keith Lewis' home. Not to possess or consume alcohol or drugs without prescription. Random drug testing. Have a mental health evaluation. Completed recommended treatment. Take any prescribed medications. $415 court cost. $100 cost of prosecution. $150 PD fee. Waive cost of supervision. And I got adjudicated, checked, and adjudication withheld. Which one is it?
Your Honor, it's a withhold. That's a mistake.
Okay. All right. Anything further?
No, Your Honor.
All right, thank you.
All right, so you have to. And Your Honor, if you want to go with any other that are out, that don't have an attorney, that's fine with me, or I can continue. I've got one more.
Go ahead.
Your Honor, the next one that I have is Michael Owens. He was set for a contested hearing today, this afternoon. We are going to enter a plea to the court for violation of probation on 19 CF 2090. If I may approach.
This is 2019 CF 2090 State versus Michael Owens. You want to enter
Admission, Your Honor.
admit that you violated probation, correct?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir, I am.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, sir.
What was the violation? I don't remember his specific case.
Your Honor, he was alleged to have violated by getting a drama license suspended, and then then probation amended and alleged that he moved to the state of Alabama.
What is the state looking for as far as a sentence?
Your Honor, at the last violation of probation hearing, the court imposed a 12.1-month Department of Corrections sentence. I pointed out to the court that would be a downward departure, but he's already been given a suspended sentence by the court of 12.1. So this is a plea to the bench, and I believe Your Honor is bound by that.
What is this defense looking for?
Your Honor, defense is asking for, to give him credit for time served and revoke and terminate, or in the alternative, to reinstate him and allow him to transfer his probation to the state of Alabama. We do have some argument if the court is so inclined.
What, reinstate his probation and transfer to Alabama?
Or in the alternative to North Carolina, he was given a good job offer in the state of North Carolina.
My friend from high school owns an AC company, and there's a school up there for HVAC. So he's offered to pay for me to go to schooling, which is a 6-month course, and after that, run the company with him.
How much time has he served in jail?
Your Honor, I believe he has served approximately 6 months.
So the state wants me to revoke and terminate, sentence him to 12.1 months.
Well, I believe the court is bound to impose
I mean,
the
that's what you're saying.
suspended sentence. I would ask that he be sentenced to what he scores on the score sheet, which is 29 some odd months. But the court's already imposed a suspended sentence.
Gotta go with that, 12.1 months, but credit for time served.
Your Honor, the only reason I'm asking to terminate today is I've already done the time for the driving on suspended in Escambia County. So the only thing up right now that I should be, I guess, punishable for, I guess, I don't know if that's the way you say it, sir, is the accusations of me moving to Alabama, which I never did.
Your Honor, it was a lease agreement that they submitted that he had signed to have his girlfriend. She doesn't work. She has a lot of health problems. He signed a lease agreement for her and her child in the state of Alabama. He remained in Pensacola homeless because he basically didn't have any money after that, and reported to probation and continued to work his job in Pensacola.
The only reason I'm asking for termination today, Your Honor, is I did put in a motion to you before I even violated probation to transfer, or for you to help me have probation transfer me to Alabama. I was in the process of doing it before I caught this violation. And like I stated at my bond hearing, had I known my license was suspended, sir, I would have been behind the wheel. I've been doing right. I've been doing the right thing. I've been going to AA meetings, taking classes so that I don't use anymore.
I think it'd be better for you to revoke and terminate and do 12.1 months. You get 6 months credit for time served, you'll be out in a month. Probably be out before they probably send you down there to do a medical checkup and release you. That's what I'm gonna do. 12.1 months, Department of Corrections, adjudicated guilty, revoke and terminate probation. 6 months or whatever, how much time he served in county jail credit. You're probably going to end up going down to the medical center down in Lake Butler and hang around there for a month and then come on back home.
Can we make sure that my time is run coterminous, Your Honor?
Absolutely not. I object to that. Any coterminous time. He's entitled to credit time
I'm
served.
going to give you credit for time served. It's 12.1 months. I mean, you know, you're going to get it.
One last thing, I was prepared for this, Your Honor, so my fiance has whites for me to be able to take with me. I would ask that
As what?
some whites, some underwears and shirts and socks.
Oh, that, I don't know if I can let you do that. I mean,
I know
They
I'm allowed to
standard,
take. Yeah.
they standard do it.
Yeah.
all right, if it's all right with security, it's all right with me, so.
I mean, they've been through it. They go through it again, though. I don't care. All it is whites.
Outstanding money stipulation, sure.
Yeah,
Well, at least you'll be free.
well, just do your time and then you're done. I keep putting you, you had 9 lives. I've warned you before, you know, so, okay, thank you.
That's all the out of custody I got.
All right, next. Mr. Williams, have you got any out of custody?
Don't have any out of custody, Judge. The closest thing I had to it was Mr. Ingram.
Mr. Gibbs?
Your Honor, the only one that I believe I had out of custody this morning was an Andrew Barnhill. We are going to be withdrawing from his case due to a conflict of interest. Otherwise, this morning, Your Honor, I have inmates.
Well, let's just start calling and bringing out the inmates. This is Mr. Colley, Joshua Colley.
Yes, sir.
Yes,
All
Your
right,
Honor.
thank you. Morning.
The Office of Regional Conflict on behalf of Joshua Lee Cawley. Your Honor, we've entered into agreement with the state for a global resolution in all of his cases, as I think the court's aware. The previous plea agreement that he had signed was forgotten today, so I had to rewrite it, but I tried to rewrite it as clearly as possible. But there are 2 pages. You'll have to go to the second page to get all of the sentences. So I just wanted the court to be aware of that. And I will have Mr. Cawley formally sign this agreement, which is exactly the same as the one we previously gone over.
This is 22 CF 1482, State versus Joshua Lee Cawley.
I'll date it for you.
Mr. Cawley, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
We'll approach the plea. Some charges, Your Honor, are being dismissed. The overall sentence with the felony charges that he is pleading to will be the 38.025 months DOC. On the second page has actual possession of a firearm charge that is going to require the first 36 months of that to be a minimum mandatory. But that's the gist of the plea. I know it's a lot.
Let me make sure I get this right with, all right, Mr. Cawley, you want to enter an admission in 22 CF 1481. You want to admit or plead no contest to violation of injunction, a misdemeanor. And then count 2, ag battery, count 3, robbery will be dismissed by the state, correct?
Yes, Your Honor.
And then in 22, is it 22 CF 1482? You want to enter a no contest plea to fleeing and attempting to elude a third-degree felony, driving license suspended or revoked, a misdemeanor, and aggravated assault on a law enforcement officer. That's count 3, correct? He's going to enter a no contest plea to those charges. And then in 23 CF 55, the state's going to dismiss aggravated assault, a third-degree felony, correct?
Yes, Your Honor.
And then plead no contest, possession of a firearm, count 2. Counts 3, fleeing, attempting to elude. Count 4, possession of a controlled substance. And count 5, possession of more than 20 grams of cannabis. Count 6, leaving the scene of crash, a misdemeanor. Count 7, driving license suspended or revoked, a misdemeanor. Count 8, battery, the state's going to dismiss or null pros, correct?
Correct.
And then 23 CF 59, you're going to enter a no contest plea to possession of a firearm by a convicted felon, second-degree felony, and resisting without violence, a misdemeanor. So you understand all that, Mr. Cawley?
Yes, sir.
Okay. So did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. And 22 CF 1481, you're judged guilty On count 1, sentenced to credit for time served, $270 court costs, $150 cost of defense. State's going to dismiss count 2 and 3. In 22 CF 1482, you're judged guilty, sentenced to 38.025 months. Department of Corrections concurrent with credit for time served, 515 court costs, $150 cost of defense. Count 2, you're judged guilty, sentenced to credit for time served. Count 3, you're judged guilty, sentenced to 38.025 months, Department of Corrections with credit for time served. In 23 CF 55, states dismissing count 1. Count 2, you're judged guilty, sentenced to 38.025 months, Department of Corrections with credit for time served. The first 36 months is a minimum mandatory. And that will be concurrent with the other Department of Corrections sentences. Counts 3, 4, and 5, you're judged guilty, sentenced to 38.025 months, Department of Corrections with credit, concurrent with credit for time served, and is concurrent with all the previous sentences. Count 6, you're judged guilty, sentenced to credit for time served. 7, judged guilty. Yes, count 7, and judged guilty, sentenced to credit for time served. Count 8, state's null processing. In 23 CF 59, count 1, you're judged guilty, sentenced to 38.025 months, Department of Corrections, concurrent with credit for time served, concurrent with all other previous cases and counts. And count 2, you're judged guilty and sentenced to credit for time served. Okay, so when you get it done, stay out of trouble.
Yes, sir. Yes, sir.
It's a lot you got going on here. It could get a lot worse, but all right. Okay, thank you.
I believe that's all I have today, Your Honor.
That's it? You don't want to stand around and watch everybody else? And
I'm going to go and judge over this now.
oh, okay. All right, next one is Jessica Carroll.
Good morning, Your Honor. Tim Gibbs on behalf of Jessica Carroll. Judge, this is 23 CF 1531. I believe we reached an agreement if I could have just one moment for her to sign. Sign right there for me, please. And then there's today's date. What you scored. If I may approach, Judge.
All right, Ms. Carroll, would you please raise your right hand and be sworn? You swear the testimony you give before this court's the truth, so help you God.
Yes, sir.
All right, this is State of Florida versus Jessica Carroll, 23 CF 1531. You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Definitely not.
Court finds the plea is freely and voluntarily entered. Court accepts it. The admission. Court's going to reinstate probation, complete original requirements, enter a complete Path of Grace rehab program, comply with all Path of Grace policies, $100 cost of prosecution, $150 PD fee, bars to bed, correct?
Yes, Your Honor.
Adjudicated guilty.
Thank you, Your Honor. They should be able to pick her up tomorrow.
Okay, thank you.
Should be able to, I mean, that's what we talked about, so. See probation, okay?
Brian. Golly.
Your Honor, Tim Gibbs on behalf of Brian Crocker. This is 24 CF 63, 23 CF 626, and 23 CF 2360. Your Honor, I believe we had a resolution this morning, and it's very frustrating. We're trying to find Mr. Crocker some of the best treatment options that we can get. He has been accepted to the ECLC pod here in the jail, but he's also been accepted to Phoenix House, which is in Ocala. It is a residential treatment. As of today, after weighing all of his considerations, all of his options, I believe he'd rather go to Phoenix House. I don't know if we can resolve that today with that, because that was kind of sprung on me just now as well. I thought we had a resolution for him to do the ECLC pod, Judge. If I can, I'd like to pass him, and Ms. Leon and I can discuss if we can resolve it today with Phoenix House otherwise.
If it's going to be a problem, I'll just do the ECLC.
You'd rather?
I don't want to mess your lives up. I'm sorry.
Are you sure?
Yeah, absolutely.
Okay.
Fine. I don't want to.
So,
I'm grateful for what they
You still
did.
know that you're waiving your credit for the 1129, right?
Yes.
Okay.
Yes.
All right. So all of these fees are going to be applied, and they're going to be sent to collections as well.
All right.
Okay. So if this is still what you want to do, you're waiving all your rights. We're not going to trial, not going to VOP hearings or anything.
Mm-hmm. Right here.
All right. I do think that Dana's going to Find approach, Your Honor.
Mr. Crocker, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
State of Florida versus Brian Crocker, 24 CF 63, 23 CF 626, 23 CF 2360. You want to admit to enter a no contest plea to the charge of, in 24 CF 63, possession of a controlled substance, third-degree felony, and possession of paraphernalia, first-degree misdemeanor. In 23 CF 626, you want to admit that you violated probation. And in 23 CF 2360, admit that you violated probation. Is that correct?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, sir, I
Are you
did.
aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. In 24 CF 63, you are sentenced, and is he judged guilty on all these?
Yes, Your Honor.
Judge guilty, sentenced to 11 months, 29 days, Okaloosa County Jail, credit for time served, complete ECLC pod.
Your Honor, despite the fact that I have to represent Mr. Crocker, the agreement does say that he waives credit for this plea in order to enter the pod.
Okay. Waive credit for time
Unless there's
served.
no objection for him to get credit, he has to waive credit.
All right, waive credit for time served if you enter the ECLC pod. $100 cost of prosecution, $515 court costs, $150 PD fee. In 23 CF 626 and 23 CF 2360, revoke and terminate. Probation, sentenced to 11 months, 29 days, Okaloosa County Jail. Waive credit for time served on this plea. Complete the ECLC pod. $200 cost of prosecution, $200 PD fee, money to collections.
Thank you, Judge.
Thank y'all.
Thank you.
Thank you.
Your Honor, Tim Gibbs on behalf of Jonathan Corey Davis. Judge, this is 22 CF 2802. Your Honor, this was set for a status hearing this morning. I've been speaking with Ms. Sandler, who's the prosecutor on this case. We're still working on negotiations. I'd like to set him for pretrial on April 22nd.
Thank you.
We'll see you then. Your Honor, Tim Gibbs on behalf of Richard Glover, right up here, sir. Tim Gibbs on behalf of Richard Glover. Judge, this is 22 CF 2131. Thank you. It's up to you. You sign right there for me, please. Today's date, if you would, please. Today's date, please. April. Your Honor, if I may approach.
Mr. Glover, would you please raise your right hand to be sworn? You swear the testimony you give for us, court's truth, so help you God. State of Florida versus Richard Glover, 22 CF 2131. You want to admit that you violated probation?
Yes.
Did you read and sign this plea and sentencing agreement form? Where the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily enter. Court accepts it, reinstates probation, modify the next 6 months to drug offender probation, complete original requirements, $100 cost of prosecution, $150 PD fee, adjudication withheld.
Thank you, Your Judge.
Thanks.
Good luck, Mr. Glover. Mr. Glover.
Amos Washington.
Your Honor, Tim Gibbs on behalf of Amos Washington. Judge, this is 21 CF 2413. If I may have just one moment. Your Honor, and also speaking with Ms. Sandler on this case, we're still negotiating. We're still trying to get some answers back. We'd like to set this for pretrial on April 22nd.
All right, thank you. April 22nd. Thank you, sir.
Thank you, Your Honor. I believe that concludes my business for this morning, Judge. Thank you. Get all my stuff out of your way.
Your Honor, this is Adam Parkinson. He's before the court for violation of probation. going to ask that we continue this case month out, please.
You want to go to May 9th?
Thank you, Your Honor.
Okay, May 9th.
Your Honor, this is Jacob Price. Originally, when I had set the status hearing, I was dealing with Ms. Glisson. Ms. Sandler is now taking over. She cannot appear this morning, so we're asking to put this on for 2 o'clock today, when she can be present.
What kind of hearing we got for today?
Well, Your Honor, the DCF has filed a motion to, set aside the plea. I mean, set aside the finding of going to Florida State
I think
Hospital.
it wasn't DCF, it was, yeah, it was.
Yes,
Yeah.
yes, sir. Yes, sir. They're supposed to be here at 2 as well.
2, okay, yeah, I got you. I remember reading that.
Be
Okay,
back at
thank
2.
you.
Your Honor, this is Brandon Severance before the court on 21 CF 1879, 22 CF 2136. Your Honor, he has a new law violation. We're asking that, I'm going to enter denial, and I ask that everything run together.
Okay, when's his next court date?
Probably the June 20.
June 24th?
June 24th, Your Honor.
All right, thank you, June 24th.
Thank you. I love you, baby. I love you. I love you. I love you. Thank you, sir. God bless you. Love you.
Your Honor, this is Stephen Sykes. He's number 18 on the docket, 23 CF 79. We've reached an agreement in this matter, if I may approach.
All right.
Oh, Ms. Glisson.
Do we have a Roberto Salas also?
Yes, Your Honor, he's in custody.
All right, you're Stephen Sykes.
Yes, Your Honor.
Would you please raise your right hand to be sworn? You swear the testimony you give for his court's the truth, so help you God.
Yes, Your Honor.
This is 23 CF 79, State of Florida versus Stephen Dwayne Sykes. You want to enter a no contest plea, the charge of grand theft, third-degree felony, and battery of first-degree misdemeanor, correct?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form? You wear the rights you're waiving by entering this plea?
Yes, Your Honor.
Anyone force you or threaten you to enter this plea?
No, Your Honor.
Are you happy with the work Ms. Gibbs done for you on your case?
Yes, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudication withheld. Sentenced you to 18 months on probation on count 1, 12 months concurrent probation on count 2, waive cost supervision, anger management class, no alcohol or drugs without prescription, 20 hours community service. Do not return to 7044 Bill Lundy Road. No contact with Ray Short. Restitution of $11,815.95. $767 court cost, $100 cost of prosecution, $150 PD fee. Thank you.
And Your Honor, that was waived supervision. I can't remember if you mentioned
Yeah,
that or
I
not.
already said that. It missed the tail hook.
Your Honor, this is Roberto Solis before the court on 24 CF 301. We've reached an agreement in this matter, if I may approach.
All right. Mr. Roberto Salas, correct?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for his court's the truth, so help you God.
Yes, sir.
This is State of Florida versus Roberto Luis Salas, 24 CF 301. You want to enter a no contest plea, the charge of burglary of a structure, third-degree felony, and Petty theft of first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir, I did.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir, I am.
Has anyone forced you or threatened you to enter this
I
plea?
have not.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, sir, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty on on both counts. Count 1, 5 years probation. Complete Phoenix House bars to bed after completion of Phoenix House work full-time or submit 3 job applications per week. Not to possess or consume alcohol or drugs without prescription. Random UA testing, no weapons. Waive cost supervision, 415 court cost, $50 PD app fee, $100 cost of prosecution, $100 PD fee. Do not return to 1278 South Verdun Boulevard, Crestview, Florida. Count 2, judge guilty, sentenced to credit for time served. Okay, thank you.
All right, good luck. Uh-huh. Your Honor, this is Seth Talbot before the court on 20 CF 2428, 21 CF 2077, 23 CF 38. If I could have the May court date, Your Honor.
May 9th?
Yes, Your Honor.
Okay, thank you, sir.
Okay.
Yes, I am. Come over by me, Mr. Howland. Judge, this is Roy Howland, 17 CF 2429. I've got some information that I need to talk with Ms. Leone about. I think we're going to be able to get the case resolved. If we can bring him back for 1:30, that'll give me a chance to talk with her when we're done doing the pretrial detention today at 12:30.
All right. Thank you.
They'll bring it back at 1:30.
You mean 12:30 or 1:30?
Well, bring him back at 1:30. We'll be here at 12:30 because we've got a pretrial
got
detention.
one.
Yeah, it's just one. It's not going to take any time. Judge, this is Michael Johnson. We're here for a bond hearing on him.
Okay.
Judge, he's been incarcerated since his arrest back on 4/6. He currently has no bond on the violation of probation, or excuse me, violation of probation. He's unemployed. He's unemployed because he gets disability. Resides here in Crestview and has lived here over 20 years. What he's requesting is that he be allowed to sign his own bond.
He's been in jail how long?
Since March 6th, Judge.
Your Honor, the state objects. First of all, he doesn't qualify for a bond. He's a violent felony offender of special concern. So he has to be held without bond. Additionally, he scores over 100 points.
How much?
Over 100 points, and I'll tell you exactly. He scores 109 months in prison. However, he also has a suspended sentence of 73 months.
I'm gonna have to no bond with. That's too much. That's too much temptation to run.
I will point out, Judge, it's a failure to register case, and those guys, just because the underlying, they always score high.
I understand. But
I understand, Judge.
All right, sorry, sir. Thank you.
Judge, this is Kaylin Jones. Ms. Jones has got 2 cases. One is a VOP that's scheduled for this morning, and then she's got a new law that's scheduled for April 25th. Well, actually, they're not a VOP. They're both new laws. What she advises is that she had been given an offer for a withheld in costs. I'm thinking probably on a paraphernalia based on what she's describing to me in the original case. The clerk's computer shows that it was passed for a status because there was something about her raising money, and she advised me it was to raise court costs. She then failed to appear on that status date. If the state's offer on this still stands, I've explained to her that she can go ahead and plea and make arrangements with the clerk's office. She doesn't have to have the money in hand before she can plead to costs. But if Ms. Leone was on the case originally, so maybe she remembers it.
Yes, so that offer was valid when she only had 23 CF 269. However, she failed to appear in that case, and then she picked up 24 CF 702. Therefore, that previous offer is revoked. The new offer would be withhold of adjudication, 2 years probation, and ECLC program.
Would that be to cover both?
Yes, sir.
Okay, Judge, she advises me that she'll take that. I'll need to draft it up for her, though. Can we bring her back at 1:30 or so as well? Okay, that's what we'll do, ma'am. We'll bring you back.
Thank you.
Judge, this is Harvey Langley, 23 CF 2556. I filed a motion for a bill of particulars in this case. He's charged with burglary. Looking at the videos, he goes onto a front porch. He doesn't take anything. He sits down for a few minutes and then later on leaves. And so I filed a motion for bill of particulars asking the state to describe for me what crime he entered or remained in order to commit. As the court's aware, burglary is basically trespass with the intent to commit a crime therein. And there is no to wit in the information, Judge.
Your Honor, I do have some case law authority citing that to prove the offense of burglary of a dwelling, the state is not required to allege in the information what underlying offense is believed a defendant intended to commit. And I am citing, there you go, Mr. Williams. It is 311 Southern 3rd 156. That is out of the 2nd DCA, if I may approach, Your Honor.
Judge, I'm not fighting whether or not they put it in the information. I'm just saying we need to know what crime it is they're alleging that he committed in order to defend him on the charge.
And Mr. Williams has cited no authority that would compel the state to include that offense.
I'm sorry, I'll cite the statute that requires or that states that burglary is entering or remaining within a dwelling, structure, or conveyance with the intent to commit a crime. If you'll look at the jury instructions, you'll find it says the same thing. At some point, you're going to have to prove what crime he was intending to commit or that he was intending to commit a crime.
And I do have the jury instruction for the court.
Ma'am, I'm sorry, I'm still speaking. I'm asking the court to direct you to tell me what crime you think he was committing. It can't be trespass, Judge. I can give you authority on that one.
Don't y'all normally include the crime?
We don't, Your Honor. I actually have a copy of the jury instructions. We can, but I have a copy of the jury instructions, and to prove burglary, count 1 of the jury instructions says the defendant entered A and you can include structure or conveyance owned by or in the possession of a person alleged. And element 2 is at the time of entering the structure or conveyance, the defendant had the intent to commit, and in brackets, it says, the crime alleged, or another bracket option is an offense other than burglary or trespass in that structure or conveyance. And I do have a copy of the jury instructions. Also, a special instruction, which is included in the jury instructions. It says you may infer the defendant had the intent to commit a crime inside the structure or conveyance if the entering or attempted entering of the structure or conveyance was done stealthily and without the consent of the owner or occupant. And in this case, the entering was done stealthily. So we would be entitled to the jury instruction, which allows the jury to infer the defendant had the intent to commit a crime.
They're incorrect on describing this as stealthy, Judge. If you look at the video, you'll see that it's not. They still have to prove the intent that he committed a crime. What their problem is they can't even tell us what crime they think he was there to commit. It's a trespass that they're trying to bootstrap into a felony.
And, Your Honor, there's not any authority that I found that says the state has to be compelled to tell defense what the offense therein is intended.
Judge, how can I defend somebody if the state doesn't tell me what crime they suspect the individual was committing or intended to commit? It's basic due process.
I think they only have to show that there was a stealthful entry, not whether he actually did something or intended to do something particular.
They have to show an intent, and they can do that by showing a stealthy entry. Now, if she's going to go ahead and go on record today and say, we have no earthly idea what he was going to do, we're just alleging it was a stealthy entry, then fine. I will try it on that basis.
She's not locked into doing that. I guess it'll be an interesting jury trial. The motion is denied. Thank you. Here's your cases. All right. Is this Kareem Walcott?
Judge, it is. Okay, great. All right. Judge, Mr. Walcott is here for a bond hearing. Basically, he's been incarcerated since March 12th. He's being held on pretrial detention. He's requesting reasonable bail. He's a student. Ultimately, he's pursuing a bachelor's degree in business administration, but currently he's fulfilling his AA, Associate of Arts requirements at Pensacola State. He's set to graduate in 2026. He's also in an extended foster care program where his schooling is paid for, but he has to attend school in order for him to stay in that program. If he's incarcerated much longer, he's going to lose his place in that program and therefore at school as well. Now, Judge, we pulled what we had for his address in the file. On file, he advises me this morning his actual address is going to be 4724 Douglas Drive in Milton, Florida. And so, Judge, we're asking for him to get a reasonable bail on it.
Has he got a prior record?
Judge, I don't know that I've got a score sheet on him as yet, so I'm going to have to defer to the state.
Judge, I don't believe he has any adult history. The state has no objection for the court granting cash bond at the discretion of Your Honor. I would agree to that with pretrial services and no contact with any witnesses in the case, no return to 394 Bracken Street. And,
all right, I'm going to say 5,000 signature bond. So you can sign
all right, Judge, thank you very much.
No contact with that address Ms. Glisson just said, and or victims, and pretrial services supervision.
Also, if we could include no possession of weapons, Your Honor.
And no possession of weapons either.
No objection to that, Judge. Honestly, I've never understood why that wasn't a standard condition.
All right, thank you. All right.
All right, sir. You'll be able to sign your... Make an appointment, come to my office, and we'll talk more, okay? Judge, this is Christian Mitchell. Mr. Mitchell has, looks like, 2 cases on for a violation of probation. He's got a new law violation that's scheduled for arraignment on April 25th. What I'll do is I'll enter denial for him on the VOPs this morning, and we'll arraign him on the 25th when he comes in.
All right, May 25th. Thank you, sir.
Thank you. Not May 25th, Judge, April 25th.
April, excuse me, April 25th. Okay.
And Judge, I believe that's all I have for this morning.
We have Ms. Merrifield today.
Yes, Judge. I have 2 cases that will be brief. The first case I have is under my name, Brainy Merrifield on behalf of Paul Carroll. It's 23 CF 469. As the court may recall, Mr. Carroll was sentenced to a DOC sentence on 3/4/24. He's reporting to the county jail today. We had set today as a status because there was a question as to restitution. ASA Leone was able to at least get me 2 of the 3 victims' restitution, so we do have a proposed order that's stipulated by the parties, if I may approach, or if the court would prefer it in the e-portal.
He'll take it right now.
Okay, if I may approach it.
Take all this other stuff I throw at you.
Thank you. And that should conclude everything for Mr. Carroll, so we don't require any additional status dates.
All right.
I also have a case that's listed under Mr. Flaherty. It's James Shoup in 24 CF 333. Mr. Shoup is present and approaching. And Judge, we've reached an agreement, if I may approach.
This is 24 CF 333, State of Florida versus James Shoup. Mr. Shoup, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, sir.
You want to enter a plea of no contest to failure to report in person sheriff's office within 48 hours on, this is one of those sex offender type registrations, is that correct?
It is, Judge. It's related to vehicle ownership.
A 3rd-degree felony, you understand that, sir?
Yes, sir.
You want to enter a no contest plea to that?
Yes.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Did you read and sign this plea and sentencing agreement?
Yes, sir.
You know the rights you're waiving by entering this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Anyone force you or threaten you to enter the plea?
No, sir.
Are you happy with the work Mr. Flaherty or Ms. Merrifield has done on your case for you?
Yes, sir.
Court finds the plea is free and voluntarily entered. Court accepts it, adjudicates you guilty. $415 court costs, $100 cost of prosecution, payable to clerk within 90 days. Sentenced to credit for time served. Thank you. Make sure you read up on that booklet because, you know, it's very detailed about what you got to do, okay? And so, okay, thank you.
And that's all I have today, Judge. Thank you.
All right.
With the court's permission, I've got a couple of plea offers to draft up, and that's all I have for this morning. May I be excused?
Yeah. Mr. Harper, what you got?
May I address it this
Okay.
morning? It's with Ms. Bassow. It's on the 2 o'clock docket. Judge Samuel Mosley, 16 CF 2013. I'm going to ask if I can continue this to the next available afternoon hearing date. We're just having some problems with an out-of-state witness getting him subpoenaed and served. This has drug on a bit, but we're just hoping to get one continuance and hopefully resolve it then.
You stand over there, they might fingerprint you.
I'm sorry, Judge. I was actually going to go ask the bailiff something, so that's why I was kind of wandering this way. Your Honor, the state understands the defense needs to have their witnesses there. We were available, but
What day you feel like you want to have this?
I think you weren't available on the 25th of April, but
no, we're not.
whenever's available after,
About like May 9th.
We can
that's
do
fine,
that.
Judge.
Got an afternoon on May 9th?
I think it's our other trial week, but we can make it work, Judge.
May 9th.
Get it done, so. We'll do it.
May 9th. Thank you, Judge.
How long is that hearing going to take, y'all think? 'Cause there's like 8 or 9 counts.
From a factual perspective, I don't think that there should be more than about 4 witnesses. So at most, I think 2 hours, including argument.
I would think so, and Your Honor, I just have Mr. McKinney. So.
Okay. All right, we'll do it May 9th then.
Thank you, Judge.
And what else we got today, this morning? Anything else? Y'all got a case back there, or y'all just visiting, or? Oh, okay. Thank you. See you at 12:30.
Yes, sir.
Thank you, Your Honor, for